We're really excited today to have Ben Cavataro here. Ben's a torts expert, but also an expert in consumer law, administrative law, and regulation. And his particular focus is on liability and safety law. He's a leading scholar of product recalls, consumer protection, corporate safety, compliance, and noncompliance, along with in the enforcement of safety law by federal agencies and state regulators. Ben's work has appeared in the Utah Law Review, the George Washington Law Review, Emory Law Journal, and JAMA Health Forum. Before joining Wayne Law in 2024, I feel like you've been there longer, he served as visiting assistant professor at Villanova University Law School. And prior to his academic career, Ben practiced law for 6 years in Washington, D.C. at Covington and Burlington, LLP. He was special counsel, clerked for the Vermont Supreme Court and the U.S. Court of Appeals 2nd District. Ben's JD is from the University of Michigan, and his undergraduate work is from the University of Florida. And despite that, we are very excited to welcome him here today to share non-enforcement of red flag laws, countering rogue sheriffs. Ben, welcome to On Target.
Thank you, Jennifer. An absolute pleasure to be here. Let me just share my screen. And let's see. Does this appear for everyone? All right. Well, thank you, Jennifer and Mark and the University of Connecticut for having me. I teach, as you said, at Wayne State Law School, and I'm here to talk about non-enforcement of red flag laws, which are risk-based statutes aimed at removing access to firearms from people in crisis who have access to guns, and ways to counter what I call the rogue sheriff's movement, or what the movement themselves sometimes describes as the constitutional sheriff's movement. I prefer rogue sheriffs because I think it more, accurately reflects who they are and what they do and doesn't adopt their framing. More about that later. Just a roadmap for today. I'm going to do an overview of ERPOs, extreme risk protection orders, or red flag orders. This will be, familiar to, I assume some parts of the audience, maybe less so others. I'm going to talk about law enforcement agencies and law enforcement officers as the key gatekeeper to ERPOs, in addition to other actors like courts and prosecuting attorneys. I'm going to talk about use and non-use of red flag laws in the states where they exist. And then I'm going to talk about this rogue sheriff's movement, its link to right-wing extremism, RWE, and then possible ways to counter it. This is really, the center of some ongoing research that I'm looking into. What are ways that state and local actors, as well as engaged citizens and advocates, can counter, this movement where it occurs? So just in overview, ERPOs go by different names. In some states, they're substantial risk orders. In some states, they're extreme risk protection orders. The nomenclature differs. What the legislation has in common is that it's risk-based and individualized rather than generally applicable, and it's effective. And I'll touch a little bit more on that later. It was first introduced in 1999. I think the first state to introduce it was Connecticut. And it gained popularity, after a series of mass shooting tragedies in the 2010s. Currently, this figure might be slightly out of date, but I think it's reasonably up to date. About 21 states and DC and the Virgin Islands have adopted some form of red flag law. And what do? They allow state courts, state judges to issue orders that remove, for a specific period of time, access to firearms by persons in crisis. And there's two different types of orders. There's usually an emergency or temporary ex parte order, and then a longer, more durable permanent order. And I'll talk a little bit more about that later. And I should say, from the legal perspective here, there's different thresholds, but they all kind of coalesce around the same idea, which are folks in crisis. They're at elevated risk of causing serious harm to themselves or other people in the near term. Some states use the term near future. Some state laws use the phrase imminent. And then there are different types of harms that the laws aim to counter. So in some cases, it could be suicide risk. In some cases, it's risk of intimate partner violence, within the home, with a cohabitant, with someone with whom the respondent has been in a relationship. And then in some cases, it's to remove access from persons who are at risk of committing mass shootings. So it's really targeting different sorts of harms. When the order is in effect, the respondent is disallowed from purchasing and possessing firearms, and it's at the state level. So there's no federal red flag law, although 3 years ago, there was a bipartisan law that allocated, I think, $750 million to support implementation of state and local gun safety programs, including ARPO implementation. So this is state-based, but with some federal involvement. A little bit about the nitty-gritty of the law, and you can see here, where do sheriffs come in? Where do law enforcement come in? It's because they're often intimately involved or a necessary predicate for the process. So it usually starts with a petition filed in the state trial court that identifies the factual basis for the issuance of the order. So that's usually the respondent's red flags, the behavior that gives rise to this suggestion of a risk in the very near future. And then also often some information about whether the respondent possesses or has recently possessed firearms or ammunition. So this is the formal document filed in court, often by law enforcement, sometimes by family members or cohabitants or other members of the community. More about that later. It's a civil proceeding, so it's not subject to the criminal process involving juries. It's not subject to the beyond a reasonable doubt standard. And then issuance of an order, importantly, doesn't impute any necessarily criminal conduct on the part of the respondent. It's a civil proceeding, but violation of it is a crime, typically. A temporary order usually lasts between 1 day and 21 days, depending on the state. I think probably median is somewhere in the middle. And those are ex parte, meaning they're issued without a full hearing, right? It's issued without, both parties coming to court fully and presenting their case, which is why it's temporary. States differ on how fast they can get to that stage. Usually, if you're going for an emergency order of this kind, due to the nature of the order, time is of the essence, right? We're dealing with respondents that are in crisis. So there are some states, I think Maryland and some other states, that are able to process and receive petitions for orders 24 hours a day, 365 days a year. Other states are a little bit more lax on that. Some states allow Zoom hearings, others do not. So you've got this temporary order. Later, after a full hearing, a final order can be issued by the court and then served to the respondent, usually by law enforcement. And then the grant denial rates vary depending on the state. The research suggests that the majority of petitions at both stages are granted, maybe a large majority. There was a 2025 study of 6 states that showed that in the neighborhood of 78% of final petitions were granted. So we're seeing that petitions are usually pretty well grounded. Judges usually accept, based on the facts presented, that there is a risk that meets the statutory threshold. And then once the order is served, the respondent has to turn in all firearms in their possession, typically to law enforcement, sometimes to a licensed firearms dealer, a holder of an FFL, a federal firearms license. Some states are better than others on this. I think New Mexico just passed a bill that reduced the time frame. Initially, it was 48 hours to relinquish weapons after an order was served, which is a really long time when you're talking about folks that may be in crisis. More typically, it's immediate relinquishment. And the standard of proof varies by stage. More common for a temporary order to be preponderance of the evidence, which means more likely than not. This is the same standard that's typical in tort law. A final order, some states have a higher standard of clear and convincing evidence, which is something in between, more likely than not, and beyond a reasonable doubt. Clear and convincing is generally formulated as evidence that leaves the finder of fact with a firm belief or conviction that it's highly probable that the factual contentions are true. And respondents, of course, can appeal for review to higher court. Respondents can move the court, can file a motion for early termination of an order, but that's pretty rare. And in fact, we see many respondents don't fight orders. Many respondents agree to relinquish their firearms rather than fight it out in a full process. So evaluating ERPO outcomes, this is going to be familiar to a lot of folks in the virtual room. We know that with both suicidality and with homicidal behavior, warning signs are pretty common. They're not universal, of course. Some people are able to mask their intentions, either deliberately or kind of subconsciously. But we know that the majority of suicide victims show warning signs. And we know that particularly for mass shooting events, as well as for other forms of violence, like independent partner violence, these tragedies don't come out of the blue. Most perpetrators have a history of interactions with law enforcement, observable concerning behaviors that are picked up upon by family members, by clinicians, by folks in the community. The effectiveness of ERPOs, I would say there's a growing body of evidence that these orders, these red flag laws do save lives. The evidence base is growing because many laws have only been in effect for a few years, right? I said the earliest one was in 1999, and then many laws have come on the books, they've come online after that. So the evidence base is still growing, but based on recent research, we know that the largest impact appears to be in reducing gun owner suicides, on the order of perhaps one life saved for every 17 ERPOs issued. Enactment of red flag law, the evidence at least tentatively suggests that it's associated with a significant drop in firearm homicide. And we know from case studies, a little bit of a weaker form of evidence, but still an important thing to consider, that there are cases where ERPOs have been used in an effort to prevent mass shootings from those who appear to be at risk of perpetrating these crimes. So evidence base is growing. These laws have been received, very well, not just by gun safety advocates, but also by courts and the broader public. So even in the post-Brune world, where the Supreme Court has articulated a fairly broad, protective in the sense of protecting gun owner rights conception of the Second Amendment, courts affirmed the constitutionality of these laws. So even in this world, where the courts are directed by the Supreme Court to look at history and tradition, courts have upheld these laws against challenges based on both the Second Amendment and the Due Process Clause. So we have very recently the Rahimi case. It's a little bit different because that was a domestic violence restraining order as opposed to an ERPO, but the standard and procedure is very similar. And there we see the Supreme Court resoundingly voting 8 votes to 1 vote that when an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed, consistent with the Second Amendment. And then we see state courts in Florida and New York finding in the ERPO specific context that these laws contain adequate procedural safeguards. They meet a really important, indeed compelling state interest, which is preventing violence. And so we see the judicial support for this is really strong, even from courts that strike down other gun safety laws. So I think that's really the important thing to consider. And then the survey research shows that the public also tends to support these laws, including large segments of the gun owning public. And the more respondents know about the law and the facts, the more respondents seem likely to support these laws. So there was a poll a few years ago, Fox News poll run in conjunction with a Democratic polling firm and a Republican polling firm that showed that 4 in 5 registered voters in the US support red flag laws. Recent academic research based on some survey data, I think this is the Guns in American Life survey, this was published in December last year, showed that adults who personally know a gun owner who is showing red flags, dangerous behavior, serious mental illness, dementia, tend to be much more supportive of red flag laws. I find this to be a really interesting finding, and it kind of connects to what we'll talk about with sheriffs later. Who can petition? It's mostly law enforcement. In some states, it's only law enforcement. In probably the plurality of states, it's law enforcement or family members or members of the household, cohabitants. And then in some states, a small but growing minority, at least one other group. Sometimes this is clinicians, sometimes this is folks involved in the education system, sometimes these are co-workers of the respondent. So you see some trend toward broadening who can petition, but the key thing is it's mostly law enforcement. And even in states where others can petition, you can see I've flashed up some, recent research sites on here. Law enforcement remains the overwhelming share of petitioners, could be on the order of 90%. It ranges based on the jurisdiction, where civilians, where non-police can file petitions. In some areas, it's as low as 3%. That's King County, Washington. In other states, it could be as high as 40%. That's Colorado. But even in that kind of extreme case where civilians are filing a lot of petitions, law enforcement still takes the dominant role. And why is that? It's for the reasons you might expect. So if you're talking about family, many family members might informally remove guns from family members who are at risk. They don't go to court because they handle it themselves. Other family members might not want to get a loved one in trouble with the law. They might fear violence or an explosive reaction from the respondent. So family members might be hesitant to get involved that way. They may not want to get themselves in trouble if they're undocumented, if they have an open warrant, if they have prior interactions with the criminal justice system. They may distrust police and courts generally. And perhaps this is the most important factor, they might not even know about the ERPO law or realize that they can petition or navigate what could be a confusing, scary process. With clinicians, it's even more unlikely that they're going to initiate petitions. Respondents might not seek or have access to care in the first place. Healthcare workers might fear litigation or legal liability. They may lack training. They might be concerned about disclosing personally identifiable patient information or running afoul of privacy law. And they may be concerned about damaging a relationship with the patient. So all in all, law enforcement is the key gatekeeper, maybe even more than the courts, because without police, oftentimes a petition never gets in front of a judge. So many states, and I want to emphasize this especially because I'm going to critique, how some sheriff's offices have behaved. Many states and law enforcement agencies have implemented red flag laws well. And the research shows that they're used more as time goes on. It takes some time after the legislature passes a statute for agencies to learn about the statute, to get comfortable and familiar with using it. I want to emphasize that there are some LEAs, law enforcement agencies, that do really well. They make the process clear. We know that the number of petitions per capita has increased. It's on the order of 10 per 100,000, according to the latest data. And the states that do the best tend to be the ones that have the good infrastructure. They may have a statewide coordinator. They may have a statewide task force. They may have county attorneys or prosecuting attorneys' offices that designate leads within those offices who are kind of the in-house experts. They may allow for same-day hearings. They may collect more data. And they may involve not only police officers, but also victim support personnel, social service organizations, getting them involved in awareness of the statute and then how to use it. And we know that in many cases, law enforcement agencies have advocated for these laws to be passed, even in states where you might not expect it. Like in Louisiana, sheriffs advocated for this type of legislation. Why? Because they want to keep their own personnel safe and because they want to keep the broader community safe. But there's ERPO deserts. That's kind of I don't know if anyone has used that phrase before. That's kind of the phrase that came to mind. If you look at the research, even when these laws are on the books, some counties studied don't really use it, or they use it very seldom. I have kind of a ripped from the headlines set of press coverage from the past few years. Some statistics you see, 33 counties in Colorado had no petitions filed in 2020. El Paso County, Colorado, which is a sizable county, it's where Colorado Springs is, granted only 8 ERPOs in the first almost 2 years after the red flag was enacted. In Virginia, we see Richmond, not a small city, state capital, file 0 petitions 2 years after the law came on the books. And then in New Mexico, fewer than 24 issued in the first 2.5 years after passage. So this isn't great, right? Some states, some agencies do pretty poorly. This is from local media in Virginia. You see some counties, some local agencies very active, like Fairfax County almost double what you see the second most active police department, in terms of their rate of usage. And then you see some use it almost never. Fairfax County, I think, borders or is very close to Arlington County. And then you see very, very few if you compare these jurisdictions. And I think it's implausible that one jurisdiction has so many more people in crisis than the jurisdiction next door. This seems more linked to how law enforcement is using it, whether they're using it at all. So why is it underused? So there's kind of two big buckets. I call one the easy one, and one is the hard one. So the easy one, or easier, because it's not a simple problem to solve, is lack of knowledge or resources. And then the more troublesome category is ideological or politicized opposition, where you see a minority, but a disturbingly large minority of law enforcement officials, particularly sheriffs in some counties, basically refusing to follow the law, even when it's been democratically enacted, on the books, broadly supported. So what about the easy case? I think there's only one or two studies on law enforcement knowledge of ARPO laws, but we see the evidence is a little bit mixed. There's a substantial minority of law enforcement officers surveyed who say they've not heard of ARPOs, or they've heard of them, but they're not really familiar with the law or how to use it. We see about 60% of respondents report receiving no training on ARPOs. This is in states that have the red flag laws. And then some, maybe up to a quarter, rate themselves as not at all knowledgeable about how to petition for ARPOs. So you see some officers who are really familiar with the process, and then others who are not. And we know this is survey data, and people might be inclined to, subconsciously exaggerate the extent of their knowledge. So it could be that the knowledge base is even lower than the figures alone appear to suggest. And there's a small number of officers that suggest that they've got constitutional concerns. This study in 2023 presented the officer respondents with various hypotheticals like intimate partner violence, a suicide risk scenario, a school shooting scenario, and an interpersonal feud scenario involving a homicide threat, and then asked the officers, how likely would you be to pursue an ARPO in each case? And you see a small number, between 2.5% and then more than 4%, depending on the scenario, that cite the Second Amendment as a reason for not filing a petition. So training might go some way to solve this problem, right? If training tells officers these laws have been widely adjudicated to be constitutional by courts, particularly in your state or particularly by the Supreme Court, that might help. What else might help? Kind of peer-to-peer training. If you have officers talking to other officers about how these laws make the community safer, make law enforcement safer, that might help. Those folks can kind of act as validators. So you see this lack of knowledge or this trepidation among some segments of the community, and that might be able to be solved by talking, by more training. The hard case is the ideologically motivated refusal. So this is from the same study by Pear and others in 2023. And the finding was that self-reported political ideology was significantly associated with officers' opinions regarding red flag laws and their general willingness to use these laws. So you see, upwards of 90% of officers who self-identify as liberal say, ARPOs are likely to reduce firearm violence, and I would use it under the appropriate circumstances. And then we see, with self-identified conservative officers, it's much more trepidatious. So this is the micro level, the line officer. And then, maybe through well-formed department-wide procedures, this kind of refusal can be mitigated, right? Because there could be more clear guidelines about when to seek an order, when to petition, and when not. It's harder when the folks at the top are the ones engaging in the ideologically motivated refusal. So this is the rogue sheriff's movement. I flashed up a few pictures of avatars of the movement. There's Richard Mack on the top. He was a Arizona sheriff in the 1990s. You've got Bob Songer at the bottom. He's sheriff of a more rural county in Washington. We have this substantial minority of sheriffs who've embraced far-right extremism. And antecedents, I'm not going to go into too much detail about, but date back to the 1960s. You have Southern sheriffs who, actively worked to counter the civil rights movement. You've got the sheriff's movement in the 1970s in the Posse Comitatus movement, the militia movement. You have the Sagebrush Rebellion in the 1980s, which was more Western sheriffs. And then you've got kind of the sovereign citizen movement in the 1990s to today. So you have this right-wing ecosystem that some sheriffs have either bought into or have kind of ridden the wave of. And this is a real problem given the powers of sheriffs, right? They not only have the power to enforce or not enforce red flag laws, but they also patrol wide areas of the country. They serve warrants, they make arrests, they service evictions, they operate county jails. So this is a really important aspect of law enforcement in the United States. Most sheriffs are not members of this movement, but those who are share some characteristics, mostly in rural or ex-urban counties, often are deeply entrenched in the local political system. They may be elected and reelected in uncontested or lightly contested elections. They may operate in areas where the local media is not very strong, right? So there are some forces that could promote accountability that are just not present. A frequent talking point or belief is that sheriffs are the highest authority in the land. This is ridiculous, right? It's not, it's ahistorical. It doesn't match up with our system of law. There's a rejection of federal and state gun laws, and then sometimes, sometimes federal authority more broadly or state authority more broadly. There's this sense that sheriffs can act independently of what the legislature says. And then sometimes there's promotion of extremist views under the guise of trainings, right? So even though the movement is fairly loosely organized, you do see some organizations who call themselves Constitutional Sheriffs of America, etc., and they try to proliferate and diffuse these views with varying degrees of success out into the wider law enforcement ecosystem. And, it won't surprise many to learn that many of these sheriffs who adopt these kind of extremist views are sometimes associated with other abuses of power, setting up a volunteer posse in a way that's not regulated by law, or, running jails in a way that's not consistent with law. So this is what we see. So what's the effect on red flag laws? We know from research that counties that deem themselves Second Amendment sanctuaries, that kind of openly vow to not follow state law or federal law on guns, tend to file fewer petitions and that issue fewer red flag orders than other counties. That's based on data from Colorado. And then this is from Ferris and Holman, who wrote a recent, very good book about kind of this right-wing extremist sheriff's movement, I think last year, found that right-wing extremism, measured by survey data, is strongly correlated with lower rates of petitioning. This is based on data from California, Colorado, and Virginia, and that sheriffs that have low rates of RWE file almost twice as many ARPOs as sheriffs with high levels of RWE. So this matters a lot, and it should be said, this undermines the text of the law, and it undermines the legislative intent of the law. Colorado is an example. You see half or almost half of counties say, we're basically not going to follow a gun law. We see in Colorado Springs, the county commission and the sheriff together said, we're going to actively resist this law coming on the books. And the result is tragedy. We have this terrible Club Q mass shooting case where a local judge, considering an earlier kidnapping case against the perpetrator, said, this defendant is stockpiling weapons and explosives and is planning a shootout, and the perpetrator needs treatment, or, quote, it's going to be so bad. So it makes you wonder, even though this is, one case, one, particular case, it makes you wonder whether, had there not been this refusal by the local authorities, whether tragedy can be averted. So what can we do? This is my last segment because I want to hear from you. 3 possible strategies: persuade and wait, tighten the law, or remove rogue sheriffs from office. One is persuade and wait. We know that despite this kind of grand talk from some sheriffs, that say, I'll never enforce a red flag law. A substantial number do. So this is an example from Livingston County, Michigan, which is kind of an ex-urban county outside Detroit, probably about 30 minutes from where I'm sitting now talking to you in Michigan, where the county sheriff, Mike Murphy, and the Board of County Commissioners said, we're not gonna implement this law signed at the state level. Within 3 months of the law taking effect, the sheriff did use the ERPO law to confiscate weapons from a man who was undergoing a mental health crisis. And then interviewed by local media, the sheriff said, well, I'm still not a fan of the law, but if there's a tool we can use to accomplish a goal, why would we not use it? So you see some sheriffs are cluing in to the fact that this protects the public and it protects their officers. This is not unique to one sheriff in Michigan. There was a recent study, I think this is 1 or 2 years ago, of Colorado petitions that show that of the 37 counties that had said, we're not going to follow the law, we're sanctuaries, petitions been filed in 20 of them, oftentimes by the very same sheriffs who had previously denounced and disavowed the law. So this is to some extent a problem that could be resolved as time goes on. But some folks are going to be more recalcitrant. They're not going to obey the law no matter what. These are folks on the more extreme end of the spectrum. So one thing to do is tighten the law to reduce discretion, right? So in New York, after the terrible, there was a racist mass shooting at a supermarket in Buffalo, New York enacted a law, this was signed by Governor Hochul, that requires authorities to file petitions when they have credible information that the threshold set by law is met. So it's saying you can't pick and choose. You have to determine, are the facts there? If so, you must file a petition, right? Now, this could still be evaded, right? Because authorities could still say, I don't think the factual predicate is met, but it tightens it up substantially. And then we see other reforms that could help out, like including ERPOs in more data collection enterprises, so you could really see starkly the county to county, city to city differences. And you could see empowering state police to get involved. Most red flag laws do provide some role for state police, state highway patrol to get involved. That's an important reform because it can kind of go around sheriffs who are just flatly refusing to obey what the legislature says. So this combination of tightening the law to remove unbridled discretion, combined with requiring more transparency, that might be helpful. And then I'll close with what's maybe my most provocative proposal, or the one that hasn't really been used before, which is seek to remove rogue sheriffs from office, particularly those who are more extreme, that just say, I am the highest authority in the land, and I'm not going to follow what the legislature says, notwithstanding the fact that red flag laws have been repeatedly adjudicated to be constitutional. So one option is the local recall. That's available probably in a little over half of states. The problem is that often requires money, it requires local mobilization. Many people are reluctant to get on the bad side of the sheriff, especially in areas where the sheriff might be deeply entrenched. Perhaps a more promising avenue is using state ouster procedures that are set by statute that allow local or county officials to be removed from office for neglect of duty. That would require involvement by some of the same political actors, right, that may be tied to the sheriff. But it's still a promising avenue, and I think it's supported by law, depending on what the statute specifically says, how it's worded, what does the state say. And in some states, not every state, but in a substantial minority of states, governors can remove elected officials when there's some sort of statutory key that's met, like malfeasance, misfeasance, neglect of duty. We see different governors wielding this power very differently. In Florida, for example, Governor DeSantis has used it in many controversial cases. Governor DeSantis has been criticized because some of these removals, appear political, right? They appear not to be based on misconduct, but based on kind of a rivalry. Other states, governors use this way less frequently. In New York, for example, the governor has this very broad power, but has almost never used it. I think the last time a New York governor removed a local official for misconduct was in the 1930s or in the 1940s. I think there's a strong argument that these powers should be used to reinforce accountability, to uphold the rule of law, and to prevent different people from being less protected just because they're in one county or the other. If there's a statewide red flag law, everyone should be able to receive its protections in the right circumstances when we're faced with folks in crisis. Now, there's important considerations here about the balance between local control and then accountability. There's some interesting dialogue on what happens when it's kind of blue sheriff, red state versus blue state, red sheriff. But I think if we put, that political aspect or that partisan variance aside, we can see the elemental principle here is that it doesn't make sense to allow sheriffs to not enforce a law when they have the resources to do so. The legislature has clearly directed them to use the law, and non-enforcement endangers the public, including gun owners and those around them. So with that, I'll stop and say thank you for listening and happy to have a dialogue.
Thank you, Ben. That was great. So much to think about. All right, I can definitely start with a question, but let me look. If you all would use your raise your hand feature, that is down in the bottom. It's with the reactions on your screen. I can call on you. But I'll get us started with a question while other people are thinking of theirs. When you were talking earlier about the distribution of states in terms of who can petition, right? We have 4 states that it is law enforcement only, about 16 states, so more than half the states, law enforcement and family or household member, and then about 9 states that are law, family +1, right? Which may be physicians, which may be educators, or both those things. I'm curious, is there any sense of whether or not the sort of implementation or the ERPO deserts varies by the number of people or the number of parties, I guess, types of parties that can petition? Does that make sense?
I don't know the answer to that question, but I do know that there's some research that finds that law enforcement petitions are a little bit more likely to be granted. I don't know that that's a universal, but it does kind of reflect the fact that, judges may, give more credence or think they may give more credence to law enforcement filed petitions because there's, sort of a built-in credibility there or perceived credibility. But I think the majority of petitions are granted no matter who files them, right? Because people don't typically file petitions for no good reason, right? There were some concerns early on that say, well, what if somebody files a petition for purposes of harassment? That's really rare. It's not that it never happens, but it's pretty rare. I think the airboat desert problem, one solution is to empower these non-law enforcement communities to file petitions, right? Because obviously, if you've got a sheriff that refuses to file petitions, but the law says family members can do so, or a social worker can do so, or a nurse practitioner could do so, et cetera, then, obviously there's this avenue to go around the recalcitrant law enforcement official. But it's not perfect because, I think I touched on this a little bit. Oftentimes these non-law enforcement folks, they don't know how to navigate the system. They don't know how the law really works. That can be mitigated a little bit by making the petition process really easy. Like in the same way we want to make, petitions for restraining orders like a simple process to file. But it's only a partial fix. You really need to combat this substantial minority of folks that say, we're not going to follow the law.
Okay. Yeah. Thank you. Carrie has a question too. Carrie mentioned that her hand raise isn't working. So if anybody else is having trouble, just type that you have a question in the chat and then I will call on you subsequently. Carrie, go ahead.
Great. Thank you. So this is super interesting. I'm wondering, right, so ERPOs have borrowed heavily from orders of protection in the domestic violence space. And I'm wondering sort of what you think as a lawyer. I'm pretty sure no one has tried what I'm about to suggest. So I'm sort of trying to get your like future legal thoughts on this. But right in, and actually also in Connecticut, when domestic violence laws weren't appropriately being used to protect, in particular, one victim of domestic violence, Tracy Thurman, she actually sued Torrington, right? There was a really horrible assault that happened. She sued Torrington. We don't have sheriffs in Connecticut. There's no unincorporated land in Connecticut. For anybody not on the call, like, we don't have sheriffs. But so she sued Torrington for sort of failure to protect and won pretty substantially in the time. And you know, one of the people sort of can attribute that lawsuit to sparking mandatory arrest laws across the country to sort of reduce police discretion and reduce the likelihood that police would sort of fail to protect someone in imminent harm or danger. And I'm wondering if like this is a path that could be explored here, right? Like if obviously it would require tragedy and standing and all of those sorts of things, but sort of suing a municipality, a law enforcement officer, agency, whatever the right one is based on that state's composition for failure to protect, if you think that is like on your bullet point of another path forward.
It's
Retroactive, not proactive. So like, obviously it's a different, you know.
It's a really interesting thought, you know, and then it's a little bit different. So like the mandatory arrest laws are a little bit different because, you know, if you have that practice, it's more proactive. Whereas if there's a lawsuit after tragedy has already struck, you know, it's kind of a different setup. One challenge here is sovereign immunity, right? It's difficult to sue the state or state officers. Generally, there are certain occasions where states waive their sovereign immunity, but there's many complexities there. You know, the other aspect of it is there a duty to protect? There's a line of case laws that basically disapprove of suits against law enforcement for not acting to protect vulnerable people. You know, there was a famous Supreme Court case in, I think it's the 1960s, 1970s, the poor Joshua case, where, you know, the line of reasoning or the outcome is essentially whether it's a victim of a crime or, you know, a victim of you know, a foster system that failed to protect a child. It's very difficult to recover, you know, from the state. And this is based on the idea that you know, courts believe there needs to be some level of discretion, so that government officials have the ability to, you know, be flexible, allocate resources in the way that they, you know, think is best without a lot of judicial interference. So I would say it's an interesting thought, but there's a lot of legal barriers to really putting it in place from the tort law perspective.
Okay, thanks.
I will unmute. We have a list of people now. Mary, I think your hand went down, but if you still have a question.
Carrie actually asked my question. So
okay. So thank you. Garen, why don't you go next, please?
Sure. Thank you. First off, Ben, great presentation. Thanks a lot. I had a comment, not a question, kind of related to what Carrie just brought up. One of the things that would be helpful, general strategy specifically here, is to compile evidence of harm that has already occurred or might occur. So these counties are identified, and it might be the work of a researcher, it might be the work of an investigative reporter to see if there are cases that might have been prevented of suicide or homicide, interview participating parties and tell the story. The Trace does that kind of stuff. Politico does that kind of stuff. But there's also a research project, potentially, NVDRS data can be used. You can get cases in a county, and there's probably enough detail in the NVDRS narrative abstracts to identify cases that at least potentially were prohibitable by ERPOs, and just toed up the numbers and by way of convincing, if not the sheriff, the people around them, sheriffs, people around them, that real harm is resulting from noncompliance. Thanks so much.
Just can I react to the comment briefly?
Of course, of course.
100% agree. You know, this is a job for the public health researchers, the medical researchers, the journalists, you know, both at the Trace and, you know, more general publications. And it's also important not just to persuade law enforcement, but, you know, build the body of evidence for courts when these laws are challenged. You know, you have to meet the history and tradition tests, but, you know, there's still, you know, even when you meet that, it's still helpful to demonstrate to a court, like, look, you know, this is what happens when you don't have these laws. We're addressing a real felt need. You know, here's the data, you know, here are the case series, you know, here's the different approaches. It's hard because a lot of it's counterfactual, right? You know, would the tragedy still have occurred, you know, even if X or Y had happened or not happened, but still really, really important body of evidence to develop. So I agree.
Okay, thank you. Stacy put her question in the chat, so I'll read it. And then after that, we can go to Michael. So Stacy asks, in terms of removal of a rogue sheriff by a governor, it seems that there is a potential for abuse of that power, especially as you mentioned in red states, where there might be an overzealous red governor. If we encourage this removal tool when it suits our purposes in strengthening ERPO laws, is there a danger that it could backfire in, you know, red states where they might remove bluer sheriffs?
Great question. And this is one that I'm grappling with. You know, I've presented to more legal audiences, and, you know, this is what they really want to focus on. I would say a few things. Number one is, just as a general principle, there has to be some sort of balance between local control and then accountability from the state level, kind of the supervisory power of the state to make sure that agents of state authority, which sheriffs are, you know, even though they're locally elected, they still enforce state law and they're still creatures. Their office was created by state law. I think it's important to strike some sort of balance there. I agree the removal power particularly, and the recall power is, you know, there's a potential for abuse. There's a potential for it being politicized. I think one way to maybe mitigate the concern is, you know, require governors to state reasons on the record and then provide some sort of expedited review model or review mode in the state courts to challenge a removal that's pretextual, right? That's based on, you know, not based on neglect of duty, but just based on, I disagree with the choices that the DA is making, or the mayor is making, or the school board is making, or in our case, the sheriff is making. I think there's always going to be some, you know, difference here. For example, if governors can remove someone for not, you know, not using red flag law, can they remove a DA for not seeking maximum sentences, or for not pursuing capital sentences, or for not enforcing laws against marijuana? There's a line of kind of legal research on what's the right balance to strike. You know, I lean more on the side of governors should use the power that's on the books. And right now it's a little bit asymmetric, right? Where you see, you know, more Republican governors using this very actively, like in Florida, and then governors in, you know, Democratic governors, for example, in New York, are much more reticent. So you see this sort of asymmetric approach to the use of power. But leaving that aside, like, I think the way to handle this is basically judicial review on the back end, where the sheriff concerned can challenge his or her removal in court and then potentially be restored to office, you know, if there's grounds to do so.
Thank you. I hit the wrong button. Michael, do you still have a question?
Yeah, so I'm actually here in Michigan with you. So I'm excited to have another colleague in our state. I'm at the Institute for Firearm Injury Prevention at the University of Michigan. And I'm really happy that you brought up the example of the sheriff of Livingston County, because as you know, he was one of the loudest kind of voices against ERPO, and then he ended up being one of the first users of the ERPO once it went live.
Mhm.
Something that we've kind of come across is I work with Dr. April Zelia. I don't know if you're familiar with her, but we've
Yes.
been kind of going across the state and talking with law enforcement, healthcare providers, who are and learning more about how they've been kind of engaging with ERPO. Something we hear a lot from law enforcement is, and you brought it up earlier in the presentation, a lot of them frankly don't feel that they have the training or the understanding of how to handle like a service and relinquishment process. There's a lot of concern about officer safety. Obviously, like we've seen a little bit in Michigan that there's that persuasion that kind of just wait and see as law enforcement learn that this is an effective tool to keep the community safe. They might change their attitude around it, but do we know about how, I guess, effective, like what sort of like changes might be going on in the training space as law enforcement learn about these laws and like the implementation of these laws? Do we know like the effectiveness or I guess like the extent to which there's being like training internally and how we as researchers ourselves can kind of inform that and help guide law enforcement and maybe through training kind of change attitudes?
First of all, go blue.
Woo!
Lived in Ann Arbor for
Nice.
3 years. But second of all, on your substantive point, I need to look more into the best practices regarding ERPO implementation via law enforcement training. I do think, the evidence shows that usage ticks up over time, in per capita terms because, folks become more acclimated to it. There's also a lot of peer influence, right? If County 1, uses it, they talk to their colleagues in County 2 even in the absence of a formal program. Um, I would be interested in seeing research. I don't know to the extent to which it's already done on do peer-to-peer validators help? Does it matter if it's, the egg-headed research team, which all of us are, egg-headed researchers. I think that's helpful. Does it matter if it's also, or does it matter if in addition to, that community, you have other officers talk about their experience, prevent case studies? I think the officer safety point in serving in airbow is legitimate, right? It is always a dangerous thing to serve an order, but that's to some extent true of many different types of search warrants, arrest warrants, traffic stops, etc. And I think I don't remember off the top of my head, which researcher has looked into this, but the vast majority of times when an ERPO is served, it goes off without a hitch, where the respondent doesn't object, they turn over their guns. Oftentimes, they're looking for an opportunity to get these deadly instrumentalities out of their possession, right? And we know the number one community that these laws protect is gun owners themselves who are at risk of suicide across the range, adolescents, adults, older folks. So, it's a legitimate concern. And police departments, sheriff's offices, they have a really hard job. But I would say, the safety point, that can be mitigated by, proper training, proper procedures, good implementation.
Thank you, Ben. Garen, do you have another question?
I was hoping I could just very briefly respond to Michael's question based on experience in California.
Sure.
Just take a moment. We've been doing this for a decade now, and I think our experience can save other people some time. Individual departments developed protocols. Those protocols got shared around. In California, San Diego County and LA County are resources, but in the fullness of time, this has kind of rolled up to our governor's office of gun violence prevention. And I've put the email address for the person who is that office. I chose those words carefully in the chat. He is spearheading a piece of legislation that's requiring uniform statewide protocols. To give an example of how this continues to be a problem, we were puzzling over why are we getting lots of temporary orders, ex parte orders that aren't followed up with orders after hearings. And it turned out that was because a bunch of agency protocols simply didn't extend that far into the process. So all of that is being cleaned up. And my recommendation is check in with Ari and get his stuff. He's pulled together a packet of resources so that you can move more quickly than we have here.
Yeah, thank you so much. I don't know if you've chatted with April about the experience in Michigan, but yeah, we've learned a lot of the same problems. There's no statewide ordinance, so we've been speaking with different agencies, and some have really good protocols, some don't even know where to start. So uh, disappointing, but also reassuring that we're not the only ones in the same boat.
I'll just add, I was in Washington, King County, which is Seattle, working with their prosecutor's office about something totally different. But when I was there, one of the things that they shared was that they developed a video for how firearms are seized and what that looks like. And it was developed for sort of gun owner concerns, but I think it may have also sort of helped reluctant law enforcement concerns, right? There's overlap in that community. And I think what we can take from sort of the trusted messenger literature, like, applies very much in police officer training, law enforcement training, et cetera. And so folks that have had good experiences or been reluctant, right, in sort of larger law enforcement meetings and sheriff's offices, maybe, you know, if you can get like an ally in those leadership positions, that could prove very useful. But I think the other part is some people just don't know what it looks like until they experience it. And there is a worry about due process from citizens, law enforcement, et cetera. And so I think we have to realize that and honestly address it in earnest and whatever that looks like.
Well, thank you. And on that note, Ben, thank you so much for joining us today and for that really stimulating presentation. To all of you who joined us, thank you for joining us and for your thoughtful questions and discussion. They are equally appreciated. The next meeting of On Target is on July 29th, and we will have Jens Ludwig here to share the behavioral economic approach to preventing gun violence. I have the link to register in the chat. But we will then also reach out, and then On Target is going to take August off and we will be back in September. So thank you all and have a great afternoon.
And Jennifer, thank you for organizing this. Thank you all for participating. And if anyone is interested in research collaborations or would like to chat, I'm more than open to that. So you can email me at cavataro@wayne.edu. Thank you.
Thanks,
Ben.
Ben. Thanks, Ben. Thanks, everyone.
Take care.
Bye.